नमस्कार दोस्तों, कुछ प्रासंगिक विषयों के रिलेवेंट टॉपिक्स के संवैधानिक पहलुओं को उजागर करने की इस श्रृंखला में आज का विषय है द एंटी डिफेक्शन लॉ, हमारे देश का दल बदल विरोधी कानून। हाल ही में ये विषय काफी चर्चा में था इन द बैकड्रॉप ऑफ सर्टन पॉलिटिकल डेवलपमेंट्स, परंतु इस तरह का राजकीय घटनाक्रम कोई पहली बार नहीं हुआ है, न ही ये आखिरी बार। Therefore, it is important for us to understand the legal and constitutional provisions regarding anti-defection law. संविधान लागू होने से 35 वर्ष तक हमारे देश में कोई दल बदल विरोधी कानून नहीं था। In the absence of anti-defection law, the members of parliament or state assemblies could change political parties at will, frequently without attracting disqualification. This was obviously a highly undesirable situation, and by and large there was consensus amongst political parties to curb this trend through statutory provisions. Thus, in 1985, Rajiv Gandhi government brought in 52nd Constitution Amendment Act and introduced 10th schedule in the Constitution as anti-defection law. इस तरह से संविधान की 10वीं सूची में जो कुछ लिखा है वही इस देश का दल बदल विरोधी कानून है। So let us examine the contents and provisions of 10th schedule. Para 2 of 10th schedule deals with disqualification on ground of defection, and there are only two conditions. The first condition is when a member of a house voluntarily gives up membership of his party, and the second one is when a member votes or abstains from vote in the house contrary to party directives. पार्टी के निर्देशों के विपरीत वोट करना या एब्सेंट रहना, इन परिस्थितियों में डिस्क्वालिफिकेशन या अपात्र घोषित होना निश्चित है। However, originally 10th schedule had para 3 as an exception clause, that is exemption from disqualification in case of a split. If 1/3 or more members of a political party in the House, if they formed a separate group, they were not liable for disqualification. Obviously, this provision attracted wide criticism, particularly because it held bulk defection as legal and individual defection as illegal. Dinesh Goswami Commission on Electoral Reforms, and so also the Law Commission of India in its 170th report recommended removal of this provision. Thus, wide 91st Constitution Amendment Act 2003, para 3 of 10th schedule was omitted. इस तरह से the anti-defection law invoked today does not recognize split in the political party, whether parliamentary or legislature party, irrespective of numbers, whether 2/3, 1/3 or any number of members supporting the split. If there is a split, there is bound to be disqualification. Well, there is one more clause at para 4 which provides for exemption from disqualification in case of merger. It states that a member of House shall not be disqualified if his original political party merges with another party, provided that more than 2/3 members of the party support that merger. What it means is that 2/3 or more members of a political party in the House represent original party and the will of the party to decide about merger or otherwise. But then, parliamentary and legislature party is not alone the political party. Political party is represented at a very large scale at organization level. So what happens to the party decision at organization level? Let us take a hypothetical situation. A political party at organization level unanimously decides to merge with another political party. That is, at organization level, unanimous decision to merge. And suppose at parliamentary and legislature level, majority of members support this merger. Say 60% or 65% members support the merger. However, if the number of members supporting in the parliamentary and legislature party is less than two-thirds, then all these members, whether 60 or 65% supporting the merger, are bound to be disqualified. Because as per para 4 of 10th schedule, two-thirds or more members of a political party in the House represent original party and therefore will of the party, and that is the law as per 10th schedule. Let us examine other aspects of 10th schedule. 10th schedule as anti-defection law deals essentially with disqualification on ground of defection. But why this provision is so important, this 10th schedule is so important for political parties? After all, a political party can initiate disciplinary action against its member under party constitution if the member is indulging in anti-party activities. And disciplinary action under party constitution could be expulsion from the party. However, expulsion from the party does not automatically lead to disqualification from the House. In fact, a member expelled from the party becomes unattached member in the House and retains his membership. That is precisely the reason that political parties, rather than initiating disciplinary action against its member under party constitution, prefer to invoke disqualification proceedings under 10th schedule. Well, as we have seen, disqualification conditions under 10th schedule are straight and simple. When a member votes or abstains from voting against party directives in the House, or when a member voluntarily gives up his party membership. Now, voluntarily giving up party membership could simply mean resignation from the party. However, as per Supreme Court ruling, inference can be drawn from the conduct of a member. That is, what was a voluntary action by a member, by an individual, is now matter of a subjective assessment by Speaker. No wonder rulings given by Speaker in this regard are invariably challenged in the court of law, and thus disqualification proceedings invariably turn into protracted court legal battles. Well, that is how anti-defection law has evolved till date. Let us hope that further development and the process of strengthening anti-defection law will take into account these issues and concerns. If you find there are any useful takeaways from this video, do like it, share it and subscribe it. Thank you. Jai Hind.